Thank you all for being here. I'm Hennepin County Attorney Mary Moriarty. Today, the Hennepin County Attorney's Office, the State of Minnesota, and the Bureau of Criminal Apprehension filed a lawsuit against the U.S. Department of Justice, or the DOJ, the U.S. Department of Homeland Security, DHS, along with their respective leaders. The lawsuit was filed in federal court in Washington, D.C., where the agencies and their leaders are located. I have been admitted to the federal bar in D.C., along with Deputy County Attorney Sarah Davis, Criminal Division Director Morgan Kuntz, and Division of Professional Standards Director Claire Deagle. The lawsuit seeks to force the federal government to provide access to evidence in 3 cases: the killing of Renee Good, the shooting of Julio Sosa Solis, and the killing of Alex Preddy. The federal government has adopted a policy of categorically withholding evidence from us related to shootings involving federal agents during Operation Metro Surge. This is an alarming change from the historical practice of evidence sharing and undermines our rights as a sovereign state under the 10th Amendment to the United States Constitution to investigate and enforce Minnesota criminal law. The lawsuit today challenging the categorical withholding of all evidence from a state for criminal investigation is unprecedented in American history. One of the sovereign states of this nation is suing for evidence regarding the deaths of 2 of its residents and the shooting of another by federal agents within its jurisdiction. Evidence that is intentionally being withheld by the federal government. On the morning Renee Good was shot and killed by an ICE agent, the BCA and the FBI Minneapolis field office leadership agreed to conduct a joint investigation into the shooting. They were in touch with our office and the U.S. Attorney's Office here in Minnesota. The first assistant U.S. attorney here in Minnesota confirmed to our office that it would be a joint investigation. This reflected the normal process of collaboration in this type of incident. Later that same day, the federal government abruptly decided to stop all collaboration and information sharing. This decision was communicated by U.S. Attorney Rosen, and it had significant consequences for our investigation. BCA agents were told they could join interviews with federal officers involved. The BCA agents were waiting at the Whipple building to join those interviews when they were told that the position of the federal government had changed and that they would not be allowed to be present. When the BCA asked why there would be no cooperation, they were directed to U.S. Attorney Rosen. Similar circumstances took place 1 week later when Mr. Sosa Solis was shot by a federal agent. The investigation began as a joint effort with BCA and FBI agents working side by side. However, the cooperation again abruptly ended. And then within days of the shooting, the federal government charged Mr. Sosa Solis for allegedly attacking the federal agent who shot him. Less than a month later, they moved to dismiss the case with prejudice, meaning it cannot be recharged, citing newly discovered evidence and factual inconsistencies. ICE's acting director, Todd Lyons, said the 2 agents had lied under oath. On January 24th, when Alex Preddy was shot and killed by federal agents, the federal government physically blocked the BCA agents from entering the scene and refused to comply with a judicial warrant. The FBI special agent in charge informed the BCA that he had been ordered to permit only the FBI to process the scene, not state authorities. These are just a few of the unprecedented actions the federal government took to block our access to evidence in these cases. Many others are noted in the complaint we filed today. As we shared publicly last month, in light of the federal government's refusal to provide access to evidence, we filed TUI demands to seek access to this evidence. Because they refused to provide us this evidence, today we filed this lawsuit. We are working on this matter alongside Attorney General Keith Ellison and his staff, as well as two phenomenal outside legal groups. The Washington Litigation Group, a law firm in DC with extensive expertise in federal litigation focused on fighting for the rule of law, and the Institute for Congressional Advocacy and Protection, a nonpartisan institute at Georgetown Law School. They are focused on protecting constitutional rights and our democratic processes. We are grateful to have their expertise and pro bono support. Every person in this country deserves transparency and accountability from their government. Minnesotans saw Renee Good and Alex Preddy die at the hands of federal agents. Julio Sosa Solis was shot, and ICE agents lied about what happened. Now Minnesotans are seeing their federal government hide evidence and obstruct investigations into these incidents. We will not sit by and let that happen. We are prepared to fight for transparency and accountability that the federal government is desperate to avoid. We will fight as long as it takes. Thank you. I will turn it over to Attorney General Ellison.
Thank you, Mary. Keith Ellison here, your Minnesota Attorney General. And I have a few comments, but I want to start by thanking the Hennepin County Attorney's Office for its hard work on this matter and all of the staff who have put so much energy into making sure that the state of Minnesota's rights and the people of Minnesota have transparency, their sovereignty is respected as it has been over the course of really years. It's unprecedented that we have had to encounter this kind of difficulty. But my comments are thus. On January 7th, a federal immigration agent shot and killed Renee Good in South Minneapolis while she was peacefully exercising her constitutional right to observe a federal operation. Renee was a poet and a mother who had just moved to Minneapolis with her wife only 5 months prior to live in a community where they felt safe. Before the Bureau of Criminal Apprehension could arrive to conduct its standard investigation of shooting scene with trained, dedicated agents from its Use of Force Division, DHS agents had removed nearly all evidence, including the car Renee was killed in and the officer's firearm. The federal government quickly announced it would not cooperate with state law enforcement in investigating the case. Indeed, they announced that they are not investigating the circumstances of Renee's death at all, and instead are investigating a signal chat that Renee's wife was part of. In response, our offices created a portal where anyone can independently submit evidence to the case. The Bureau of Criminal Apprehension continues to safeguard that evidence. On January 14th, the federal immigration agent shot Julio Sosa Solis, the father of a 3-year-old boy, while he was in his house in North Minneapolis. The incident provoked an hours-long standoff between peaceful observers and federal agents, with observers being repeatedly tear gassed. And I know because that's my neighborhood, and I could taste the chemical irritant in the air. Federal agents claimed Sosa Solis attacked them and that they shot him in self-defense. The federal government has since acknowledged that those agents lied. The attorney who assisted Mr. Sosa Solis' family during the standoff told the Star Tribune, quote, "I would have never in a million years thought that I would be telling a group of completely innocent, nonviolent human beings how to not get shot in their own home by our government," unquote. The federal government announced yet again it would not cooperate with law enforcement, and the Bureau of Criminal Apprehension has done its best to collect evidence in the case. On January 24th, the federal agent shot and killed Alex Preddy in South Minneapolis while he, too, was peacefully exercising his constitutional right to observe federal agents. Alex was a federal employee, a member of the AFGE union, an ICU nurse who worked with veterans. Agents from the BCA's Specialized Use of Force investigative team quickly showed up on site to collect evidence. Federal agents blocked them from doing their jobs. The BCA then won a search warrant in court to gain access to the site. Federal agents continued to block the BCA's access to the site, and the federal government announced yet again that it would not cooperate with state enforcement in the investigation of Alex's death. The real threat that evidence in Alex's case would be corrupted or destroyed led us to file a lawsuit. Less than 12 hours after Alex was killed, to preserve evidence in the case, we had to act. Not 2 hours later, the court issued a temporary restraining order that the federal government must preserve evidence. Although the court lifted that injunction a few days later, it found that the federal government, quote, failed to safeguard, unquote, key evidence and, quote, in compliance with normal law enforcement processes, unquote. Today, we are expanding and we are pursuing this lawsuit to require the federal government to preserve evidence in the Alex Preddy case, to include the cases of Rene Good and Julio Sosa Solis. I have to stress, friends, how absolutely extraordinary it is, how rare and unprecedented it is, how completely unnecessary it is, if justice is our goal, for us to have to file this lawsuit. The federal government has refused to cooperate with state law enforcement, which is unique, rare, and simply cannot be tolerated. We can't sit around and let them do it. Cooperation between the federal government and the state law enforcement in Minnesota is a routine thing. Local, state, and federal law enforcement agencies on the ground here in Minnesota have for decades worked with each other on a broad range of things. Those relationships have absolutely nothing to do with who's in elected office and everything to do with a common desire to keep people safe and solve crime. It is extraordinary that we need to file this lawsuit at all. We argue in this lawsuit that we share jurisdiction with the federal government in this case. These incidents happened in Minnesota and fall under Minnesota state law, regardless of the fact that the federal government's agents are involved. The Fed's choice not to share evidence with us is arbitrary, and it is capricious and has no rational basis. And we are also choosing to refile this federal lawsuit in District of Columbia rather than Minnesota. While the shootings took place in Minnesota and much of the evidence we want is here, Washington, D.C. is where the decisions not to cooperate with the state law enforcement and deny us access to evidence are being made. There are compelling reasons to leave this case. In federal court in Minnesota, and the decision to refile it in D.C. was not an easy one, but it is the right one. It is the right one. As prosecutors, our job is not to pursue particular outcomes. It is to be ministers of justice, to follow justice wherever it leads us without fear or favor. County Attorney Mary Moriarty and I have said from the very beginning that all we want is to conduct a fair, impartial, and thorough investigation into the shooting of Mr. Sosa Solis and the deaths of Ms. Good and Preddy, and to follow standard procedures while doing so. All we ask for is for the federal government's cooperation, which the people of Minnesota are entitled to and have been denied thus far, which is why we're seeking relief from the court. Here's a copy of the complaint. And thank you for your time and attention.
Let me add some things here. So when Alex Preddy was killed, as the Attorney General said, we filed a suit in federal court to preserve that evidence and make sure that it wasn't altered. As the Attorney General said, we won a TRO, a temporary restraining order in that case. And then there was a hearing the following Monday where the federal government swore that they were following their own policies. The judge was satisfied as to their representations. In that lawsuit, we got what we wanted. We got the judge to have the U.S. Attorney's Office on the record, or DOJ, I believe, on the record, saying that they would preserve this evidence and that they would not alter it in any way. That lawsuit has been dismissed. This lawsuit is completely separate from that. This lawsuit is to force the federal government to give us the evidence that they've been hiding from us and withholding from us. So I just wanted that to be clear. I know a lot of this is really complicated. I just wanted to clarify that. Questions?
Question on what the normal course of things would be without this lawsuit. If DOJ had no intention of investigating or pursuing charges, for example, what would they do with Renee Good's car, which apparently is being held as evidence?
Well, the question is about what the federal government is doing with Renee Good's car.
And would they give it back?
Would they give it back?
Yeah.
So I have to compliment Drew Evans, our superintendent to the BCA, who has tried endlessly to work with federal agents to get access to that car, which we understand was shrink-wrapped and just being held in a warehouse. He has worked really hard at that, but we have received an email, a final decision from the federal government that not only would the BCA not have access to that car, I believe they're shipping it elsewhere. So, I suppose in the normal course of action, once the case or the car had been processed and all of the proceedings had ended, I imagine at some point that car would be returned. But obviously, they haven't even processed it, and we don't know whether they will. And we'll continue to try to get access to it, and we're certainly hoping, especially with this lawsuit, that the federal government will give us access to that car. Matt?
Do you have any idea if the feds are even investigating any of these shootings or taking any steps? What have you heard about that?
Right. The question is, do we have any idea whether the feds are investigating any of these cases? We know that they are not investigating the shooting of Renee Good. As the Attorney General said, our understanding is that they are conducting some kind of investigation into Becca Good, Renee Good's wife. In terms of Mr. Sosa Solis, well, I should say, I'm going to repeat this again. Because it's the history, the practice here that local entities, the FBI here locally, the BCA, the U.S. Attorney's Office, our office, have worked collaboratively over the years. The people here would really like to work together, but these directives are coming directly from the administration in Washington, D.C. So they're not sharing with us exactly what they are doing in any of these cases. Clearly, we don't have confidence that they are going to conduct an independent investigation into any of these shootings. And that is one of the reasons why we continue to conduct our own investigation. And our hope is that we will be able to make an announcement about all three of these cases at some point.
Can I just add, Todd Blanche, the number 2 at DOJ, has said that they're not investigating Renee Good's homicide and that their focus is elsewhere. And you all will remember about 14 assistant U.S. attorneys could not continue to be a part of that and, as a matter of conscience, quit because of their objection to that decision. So.
You said that you've gotten a lot of evidence through your portal and that people really come forward. Could you, I'm sure there's always, in any case, evidence that you can't get your hands on in any prosecution. Do you think you could still go forward with what you have? Because it sounds like you've gotten a lot.
So the question was about the portal, the understanding that we've received a lot of information from the portal. That is true. We got over 1,000 submissions on the Good and Preddy cases. And I've said this before. I think in any case, we rarely ever have a perfect case with absolutely all of the evidence that we would like. So it depends on what evidence we have, what we need to prove. And I feel somewhat confident that we will have enough evidence in these 3 cases to make a decision. I've been clear that I don't know what that decision is going to be. We're not going to make it until we feel prepared to address whatever issues may come up. But I've also said this too. You know, as the Attorney General said, they took the gun. They took the guns in all of these cases. So we don't expect to have that evidence. However, it's very clear that all 3 of these people were shot. And so for us, evidence from the medical examiner is going to be more important, and other evidence will also be important as well. So not having those weapons, I don't see as a barrier for us to make a decision.
If I could just ask you, Bruce, as a follow-up, are you saying, it sounds like what you're saying is that you believe you will have enough evidence that you will be able to make a charging decision in these cases, even if you don't get this?
I believe that we will have enough evidence at some point here to make a decision. I'm not saying, we haven't decided what those decisions might be. We are still, and the BCA is still collecting evidence. And so when we have as much evidence as we think that we are going to be able to collect, we will be having discussions about whether charges are appropriate or not.
Regardless of whether the federal government turns out to step over. I mean, it sounds like you guys are marching forward on your own.
Oh, absolutely. We hope that the federal government cooperates and gives us this information. And that's why we're doing this litigation, hoping to get it. At the same time, we continue to go forward on the investigations here. And if at some point it appears we can make a decision without some of the evidence that we don't have, we will make that. Andy.
If you win this lawsuit and the Trump administration still continues to not cooperate, I mean, he's made comments about, especially lower court judges in the past, they indicate that that would be a possibility. Is there any kind of recourse, or do you try to go to the United States Supreme Court with this?
So the question is, what if we get a ruling in our favor on this lawsuit and the Trump administration doesn't comply? I think we're a long way from that. Our focus is on this lawsuit. Obviously, we're litigating that. We will get a judge assigned to us, and we'll start that litigation. So we're far away from that. But in this lawsuit, I imagine that whichever way it goes, there will be appeals. The party that's not happy with the decision will probably appeal.
Mary, can you talk about the obstacle the Supreme Clause of the Constitution poses in this case? And in my reading, I saw little in the way of case law. Tell me what that means. Does that mean that we're in uncharted waters from a legal standpoint?
So the question was about the supremacy clause, the Constitution, and what kind of barrier, if any, that would be to our prosecution if we decided to file charges.
No, I meant in this lawsuit.
Oh, in this lawsuit. No, this lawsuit, so this lawsuit is civil. And I think, thank you for bringing that up. This lawsuit is civil. Any potential criminal charges against the officers are criminal. So the supremacy clause defense would be something for a federal agent to raise should we charge these cases. This civil lawsuit is essentially, we have jumped through the appropriate hoops, made the appropriate request to a federal agency for them to give us the information that they will not give us. They have declined to do that. This civil lawsuit is about asking a judge to force them to give us that information.
And they can lean on the supremacy clause to decline to provide information from a criminal matter?
No. So remember way back I had said, people had asked, well, why don't you just subpoena the information that you want? You can't just subpoena a federal agency. If you want information from a federal agency, you have to go through this process, and you have to make a case for why you should get it and why the federal agency should have to spend the time giving it to you. Are there privileges? Is there sensitive information in there? So this lawsuit is about trying to get them to comply with their own administrative practices. So that's what this is about.
Okay. And on the case law issue, am I right that there seems to be little precedent you're leaning on or building on?
Right. You know, certainly TUI cases are litigated, but in our research here, this type of TUI litigation in death cases here, where the federal government is actively obstructing a state's ability to get evidence, is unprecedented.
Is it your understanding that the DOJ holding the evidence in Renee Good's case, is it because of the investigation into Becca Good, or is it just that they can indefinitely hold that evidence for as long as they want?
So the question was about, do we have any idea why the federal government is still holding the evidence in the Renee Good shooting? We don't. What we absolutely know is that they will not share that with us. They've made that clear multiple times. So we don't know the answer to that.
Attorney General Ellison, can you talk about the nature of this, you mentioned it, this differentiation between the working relationships with the local, federal law enforcement agencies and this seeming disruption that's coming at a level that might be beyond them? Is that kind of what your sensation is?
Look, our experience is that we work with the federal agents from the ATF. We work with them on trafficking issues. We work with the FBI. It is routine. I'm sure that Mary's office probably has multiple interactions a day under normal circumstances with federal agents because public safety is all of our business. This is extremely unusual, and so my position on this matter is that it is something that is arbitrary, it is capricious, it is coming from Washington, it is a policy that they're pursuing, and it really has scary implications for the whole country. This is not the only place where a state might want to investigate what happened to one of their citizens at the hands of a federal agent. So this is why we have to move forward.
And no word either if they're investigating the Petty shooting. I know you mentioned Renee Good.
You know what? Todd Blanche has said out of his mouth what's going on in Good. On the other two matters, they're just not cooperating, and we don't have any reason to believe that they're going to suddenly change their mind.
Are they not cooperating, or are they engaged in a cover-up?
Well, I think that is a decision for commentators to make. I don't think it would be unfair to draw that conclusion, but I'm not going to accuse anybody of that right now.
Can I answer? I'm just going to go back, Esme, to your question. None of us can really speak to the motives there, but it is unprecedented that officers, agents shoot and kill people in a community and that there isn't a thorough and transparent investigation. That is unprecedented as far as I know. The government should want transparency. Frankly, everybody should want all of the evidence shared with the entities that are looking at the case. And you only need to look at the Belter case to see that we can do joint investigations. Both of us can charge if we see fit. That's the way, as the Attorney General said, that we have operated here. And so I think, for the federal government to just absolutely refuse to share any of this evidence, like the Attorney General said, you can make whatever conclusions you want, but it is unprecedented, and it is so harmful to the community to trust. How is the community supposed to trust that there is process here? I remember, I think it was Blanche who said, if there was something to investigate it, we'd investigate it, but there isn't. There has to be an investigation anytime a federal agent or a state agent takes the life of a person in our community. And ultimately, the decision may be it was lawful. You don't know, but that's why you do the investigation. You are transparent with the results of that investigation, and you are public with your transparency about the decision and how you got there. And so that's another reason why this is critically important, because everybody can see videos and that kind of thing, but everybody needs to know what the evidence is and to see their government make a decision and explain why the decision was made.
Do we know where the agents are, or has there been any attempt to locate ICE or any border patrol agents? And could there be like a extradition issue if they're in?
So the question is, do we know where the agents are? We do not. In fact, they have not, ProPublica identified the two agents in Preddy. We do not have that information from the federal government.
You closed the portals for the killings with Running Good, so you feel like you've gotten everything you needed from the public there?
So we kept those open for a very long time. As I said, we got over 1,000 submissions. I continue to believe that we got some information that we would not have received otherwise, just because you don't always know who's there or who saw something or who drove by. And we waited long enough that we thought, if we got we would have had things by now, but if people have other things, we are still open to taking those. And as you know, we switched over to our Transparency and Accountability Project, where we did get quite a few submissions on those other cases that we are investigating.
You said you would file to join the federal bar in Washington, D.C., and it sounds like several others of your team have also
Yes.
done that. Does that sound like you folks are actually going to go personally to Washington, D.C. and fight these cases?
So the question is about our admission to the federal bar. Technically, admission to the federal bar is just a process. It's paperwork, that sort of thing. To put our names on litigation, we have to be admitted to the bar. So that's simply a technical process. Exactly of who will be there and when, that's something to be determined later. Thank you, everybody.